Okay, awesome. Uh, Good afternoon, everyone. Welcome. Thank you for joining us. Uh, Access to Justice Week BC 2026. We're in the full swing of things. My name is Jenny Gu, and I'm honored to be your host today for today's event. I'm a lawyer practicing in British Columbia, and I also serve as a director on the board of Amici Curie Friendship Society, or AC, which is the organization hosting today's event. I would like to begin by acknowledging that I'm joining today from the traditional, ancestral, and unceded territories of the Musqueam, Squamish, and Tsleil-Waututh nations. I invite everyone joining today to take a moment to reflect and acknowledge the Indigenous lands from which they are participating. AC acknowledges the traditional territories of the many diverse Indigenous peoples in the geographic areas that we serve. We offer this acknowledgement with respect and gratitude as a service provider to continue learning about the impact of colonial harm and taking action toward true reconciliation. By registering for this event, you would have seen and agreed to AC's event code of conduct. We'd like to remind everyone that the code of conduct will be enforced during this event, and we will not tolerate any harassment or disrespectful behavior. The AC team will be monitoring the meeting, and given that this is a live event, we reserve the right to mute or remove anyone without notice who is displaying any disrespectful behavior. Now that that housekeeping is out of the way, just a quick introduction of AC. For those who may not be familiar, we are a nonprofit based in BC, and we're dedicated to removing barriers to accessing legal services. Our volunteers help British Columbians, especially self-represented litigants, understand legal procedures and complete paperwork for free. We provide our services based on the principle of equal access to justice, regardless of a person's means. And that mission is what brings us together today. Across courts and tribunals in BC and well beyond, we at AC are seeing a growing number of self-represented litigants using artificial intelligence tools to draft documents, research legal issues, and prepare for hearings. AI presents real opportunities. It can lower costs, improve comprehension, and help people engage with complex systems. But at the same time, it raises serious questions about accuracy, fairness, procedural integrity, and how decision makers should respond. Today's panel asks a timely and important question. How are courts and tribunals actually working with self-represented litigants who use AI, and what does that mean for access to justice? Before we begin, I'll briefly walk through today's agenda. We'll start with a presentation from Professor Amy Salazin, who will speak about how BC courts and tribunals are currently working with self-represented litigants who use AI. We'll then move into a panel discussion moderated by Professor Andrew Pillier, featuring leaders from courts and tribunals across the province. We'll then open the floor to a brief Q&A session, and we'll conclude with closing remarks delivered by Professor Pillier. As a note, the Zoom chat will be reserved for questions only. The questions will be coming to co-hosts. I'll be monitoring the chat, so if you have any questions during the event, please feel free to throw them in the chat, and I'll collect a few questions to ask our panelists at the end as time permits. As a reminder, please keep your questions and language respectful. Now it's my pleasure to introduce our speakers and panelists today. We are very fortunate to begin with Professor Amy Salazin, who is an associate professor at the University of Ottawa's Faculty of Law. Professor Salazin is a leading scholar in legal ethics, professional responsibility, and the regulation of the legal profession. Her work has been at the forefront of examining how emerging technologies, including AI, intersect with legal practice, courts, and access to justice. She brings both academic depth and practical insight to this conversation, and we're grateful to have her set the stage for today's discussion. Our panel discussion will be moderated by Professor Andrew Pillier. Professor Pillier is an associate professor at Thompson River University's Faculty of Law and is also the research director at the BC Access to Justice Centre for Excellence at the University of Victoria. He's also a director of AC. Professor Pillier's research and work focuses on improving access to justice and access to legal services. He brings a thoughtful and balanced approach to complex systemic issues, and we're delighted to have him guiding today's conversation. Joining us on the panel are an exceptional group of leaders from BC's courts and tribunals. We have Tim Outerbridge, Registrar of the BC Court of Appeal, who brings deep institutional knowledge of appellate procedure and court administration at the highest level of the provincial court system. Next, we have Judge Sue Weishart, Associate Chief Judge of the Provincial Court of BC, whose experience includes extensive engagement with self-represented litigants and the day-to-day realities of access to justice in the courtroom. Next, we have Shelley Lopez, Chair of the Civil Resolution Tribunal, which is Canada's first online tribunal. Shelley has experience facilitating digital justice and innovative dispute resolution. We also have Emily Drown, Chair of the Employment and Assistance Appeal Tribunal, who brings valuable insight into how administrative decision-making intersects with vulnerable populations and self-represented parties. And last but not least, we have Erin Frew, Chair of the Property Assessment Appeal Board, with experience overseeing adjudicative processes that frequently involve self-represented individuals navigating technical and procedural issues. Together, this panel offers a rare opportunity to hear directly from those who are shaping and responding to the role of AI. On behalf of AC, we would like to thank Access to Justice Week BC for providing this platform, and thank you to our speakers and panelists for joining us today and generously sharing their time and expertise. And thank you all for everyone joining. We encourage you to engage, reflect, participate in the Q&A. This is a rapidly developing area, as we all know, and thoughtful dialogue is essential. So with that, I'm very pleased to turn things over to Professor Amy Salazin.
Thanks for that introduction, and thanks everyone for joining us. I'll just have to maybe get the share screen function enabled. If maybe these slides are taken down, I can do that. Perfect. Always takes a while to get all the technical things in order here. Okay, great. So yeah, thanks for the introduction, and thanks again to everybody for joining us here today. I'm really excited about the conversation we're going to have. I'm going to start with about a half an hour of comments here. And I thought what might be most useful for me to do is first share some of the observations I have relating to self-litigants, AI, and courts of tribunals. What are we seeing, particularly over the last 3 years? And then second, maybe offer some general thoughts about what we might want to be thinking about, where we might go from here. And my goal there is really to set the stage for the really stellar panel. You've heard who we have with us today. It's really exceptional. And these are the people with a deep on the ground experience of what's happening in British Columbia. And so hopefully this will work kind of together for me laying some of the foundation, then to hear, in a lot of detail about what's happening in the courts and tribunals in this province. So I'll start with 7 observations. A first observation to make is there's a lot we don't know. No one has a complete, detailed, comprehensive picture of what's happening with self-litigants and AI and courts and tribunals in Canada. We do know there's some courts and tribunals that require litigants to disclose if they've used AI, but that doesn't happen before every court and tribunal. And even where there's disclosure mandates, there's no kind of general global public reporting about who's disclosing what and how many times. Maybe some kind of piecemeal disclosure, but nothing that gives us a complete picture. And then even where there are disclosure mandates, we've learned that people don't always disclose if they've used AI. And we don't really have a reliable way to kind of vet ex post if people have used AI in their submissions. So in some ways, it's a bit of a black box, which leads to the second point here. that when we often hear about AI and self-litigants, it's usually when things go wrong. So those cases that maybe most of you have seen where fake authorities get included in submissions. And as well, I'll cover in a bit, when things go wrong, it's a really serious matter and it's causing, a lot of challenges. But I do think we need to be, a bit cautious to not take the bad as the entire story that's being told here. There may well be, things that are going right with AI, and some of our panelists may be seeing that. They aren't always the things that are going to get reported in the news or reported in the case law. So I think that's helpful to keep in the back of our minds that some of the reporting cases of the things going wrong, um, very important to take note of, but not the entire story. With that, point, I did think that this December decision from the BC Workers' Compensation Appeal Tribunal was notable. Here we have an example of a tribunal acknowledging an instance where a self-litigant did disclose AI use. The tribunal considered that use and found that it wasn't a case where the written submissions were kind of substantively generated by AI. Rather, AI was largely used to organize evidence and written submissions. And the tribunal concluded that, the arguments and thoughts in the written submissions were still the litigant's own. They could be given weight. And so I think this is an example, maybe one of the more rare examples where we do have some reporting of things going right, or at least things going okay when AI is being used. And I think, it's helpful when we have decisions like this that give us maybe a bit of a fuller picture of what's happening. Um, but now to the things going wrong area of my presentation. There's a few different trouble spots. I think the most prominent one that many people have heard of are instances where self-litigants file material that include problematic AI-generated legal authorities. And I've been working with a student to try and track the number of cases where this is getting reported in Canada. And here's a bit of a graphic that's showing the instances of this happening. Main reason I want to put this up there is you can see kind of in 2023, 2023 and 2024, kind of petering of instances of this kind of happening, and then much more of an explosion in 2025. I think 60 cases or so of reported cases we found before courts and tribunals. And so this is what we're seeing across actually the globe, an accelerated trend of self-litigants and also lawyers using AI in an inappropriate way and filing problematic AI-generated legal authorities. And this is just really, really the tip of the iceberg. There's so many instances where this is happening, and for a variety of reasons, not getting written up in a decision. I mean, it's dealt with orally, or there's a written decision, but it's not getting put in, Canley, Westlaw, or Lexis. So, and certainly talking to adjudicators across the country, this is very, very much just the tip of the iceberg. And noting too, it's not just self-litigants where this is happening, it's also lawyers as well. In terms of why this is happening, I'm not going to get into a big technical lecture about AI. In terms of some broad brushstrokes, and maybe this is familiar to many of you in the audience, but maybe not everybody. When you use a tool like ChatGPT, for example, for legal research, it's not a type of tool that's doing like a rules-based search in a legal database of verified cases. Essentially, what it's doing is it's using statistics to predict what things go together. And it's had a really massive data set to look at to kind of run these statistical analyses over. And so in that massive data set, it's seen things like legal citations and knows how to create something that looks like a legal citation. It's seen also real statements of law. So in some cases, it may give you accurate statements of law, particularly if it's a common type of legal issue. But fundamentally, that's not kind of what the tool is designed to do in terms of give you, accurate statements of case law. It's probabilistic at its foundation. And so it's not going to always give you accurate and consistent outputs. On top of this, I think it's important to note that the way these models are trained, and we could, again, spend a long time on this, but two things to note is that, a tool like ChatGPT and OpenAI, who develops this tool, is very clear about this. The tool's trained to guess, and it's training and gets rewarded from guessing instead of saying, I don't know. And so that also feeds into the inaccuracy issue. The preference that's built into this tool is to give you an inaccurate answer over no answer. And then also to varying degrees, the tools can also be trained to please. There's a bunch of interesting work on how these tools are sycophantic. And maybe some of you who've used these tools have seen this. A tool can be very flattering to the user. That could really feel good sometimes personally, but it could be dangerous if you're trying to get objective results. The tool is going to be maybe inclined to tell you what you want to hear. And those are features of the general models, and each model may have different elements of these features. I did want to also mention, and something I'll get to a bit later, is that you can build specialized tools with different types of safeguards, different types of connection to verifying data. There are some better practices. And so here I'm talking mostly about some of these general purpose tools. And these are the tools, for the most part, that are landing people in trouble. In terms of how courts and tribunals are going to react, this is true, I think, in BC, but also across Canada. It's really going to vary from case to case. And sometimes, the tribunal or court will just have parties refile. Sometimes the adjudicator will try to work around the issue if the problematic authorities aren't really essential to deciding the issue. We are seeing kind of, I don't know if increasing, but we're definitely seeing willingness to also order costs against a self-litigant. What's awarded and if it's awarded may depend on the particular rules and jurisdiction of that tribunal or court. But we're certainly seeing this happen both against self-litigants and lawyers. I think another important thing to point out is that sometimes this issue gets framed just as fake cases, and that could be part of it, where you have legal submissions and just have totally made up, names, totally made up citations. One thing that's challenging, though, is sometimes you also have these tools produce names of real cases, but then the law that's being described is totally disconnected with what that case is about. So you have wrong statements of law, or maybe kind of half of a real citation mixed with another half of a case. We can also have quotes that are purportedly from cases just being made up as well. And so there's more what I might call subtle hallucinations that can be part of this, and that creates some challenges. Um, Another thing to mention, this can also be framed often as a ChatGPT issue. Of course, there's other general purpose tools. I think one thing that I learned about in the last year is the problems that Google AI is also posing for self-litigants in particular. If people have used Google recently, they may see that there may be an AI overview at the top of their search results. Many people don't realize that this is actually AI that's being used there. They don't realize that those results can be inaccurate as well. And sometimes those results will, link to authoritative sources, but then kind of remix the information, provide wrong information. And I've heard from some tribunals in particular that this has led in a number of cases for people to file materials where the tribunal doesn't have jurisdiction or cite wrong statutes because of the Google AI result. And so that's causing some problems as well. I think also worthwhile to note how difficult it can be for anybody, but also particularly a self-litigant to try and verify when it comes to legal content, AI generated material. So again, there can be those subtle hallucinations that I just mentioned. It's not enough just to check to make sure the case is real. And if you're not legally trained, it can be very hard then to kind of parse out, is this an accurate statement or not, what the tool is giving me. I put up there also the issue of fluent outputs. And another challenge, I think, for everybody who looks at AI generated outputs is just how polished and convincing the outputs can be. Problem is just because the form looks good, we can kind of be lulled into thinking that the content is good. And there's actually, I'm working with a psychologist on looking at some of this stuff. There's research that shows, and this is probably unsurprising, the ease with which we can engage with a text can actually, in our brains, breed overconfidence in the content of the text, make us believe the truth or the accuracy of the content of the text just because of the form. And so in some ways, as we get more and more AI content in our world, we have to start reworking some of our intuitions. It can look very good, but it can be very bad, and that can be a danger. And I did some initial writing about this in a column on slaw.ca in the fall, if you want to read that. And I find it really interesting. Moving on to a second trouble spot, there's three of them. This moves us away from law and towards evidence. And so we're also seeing, to a lesser extent, but this is also growing, self-litigants using generative AI to either create or analyze evidence. And I'll give some examples of what I mean right now. One of the first cases was from the Civil Resolution Tribunal, where a litigant wanted to or attempted to use ChatGPT to prove that two emails and evidence came from the same device, essentially trying to do a forensic analysis using ChatGPT. This was rejected by the tribunal, indicating this kind of evidence is going to be unreliable at best. We've seen other examples. There's a few in BC and across the country where people are presenting kind of medical evidence or medical definitions or diagnostic criteria that ChatGPT has given them. Again, this is consistently rejected. I thought this one was interesting just because of the subject matter. Someone provided evidence response, a ChatGPT response to a question about whether or not he would have made a connecting flight in time. Again, this evidence was found to be unreliable, and the court was given no weight to it. And so I think for a variety of reasons, I think it's quite correct that ChatGPT is not going to be a good expert in a case, and courts and tribunals are not accepting this evidence as reliable. But certainly another area I think both adjudicators and self-litigants need to be aware of. This is maybe not the best kind of expert that you should be presenting before the court. Third and final trouble spot. This is something that doesn't really appear in reported decisions, but something I've been hearing about when I talk to adjudicators, is that there are a growing number of people, self-litigants, who are using or wanting to use ChatGPT to give testimony or to participate in things like mediations. And certainly in the online context, this can be something that someone can do, and it may not even be immediately apparent. I think certainly understandable why this happens for a self-litigant, maybe in a position where they're very nervous about going into this formal court proceeding and testifying. It's a very unfamiliar environment, or they want to be able to, present their case as best possible, and this seems like a tool that can help them. Talking to people, adjudicators, certainly hear, and it makes sense that ultimately this doesn't really tend to help people because it often presents their information in a way that may be disconnected to the true facts, or disconnected to the story, the authentic story the person wants to tell. And certainly if this is done kind of more secretively, there could also be some rules and stuff that are being violated. And so, I think this is something, again, that courts and tribunals need to be aware of the possibility of this happening, and also kind of self-litigants understanding that this is likely something that a court or tribunal is not going to permit in terms of kind of a coach on your computer, and the reasons, why that might not be seen actually as the best way to be presenting your evidence. So those are kind of three things I'm kind of seeing in the environment in terms of different self-litigant use. The questions of deepfakes is also something looming in this context. And so when we're talking about deepfakes, we're talking about, the increasingly accessible and powerful technology that can create realistic but fake audio, image, and videos of people or events. And so this technology, you may have seen some of it, it's getting cheaper to make, cheaper to access, and more powerful. And certainly, given how easy it is to do things like clone people's voices, there's technology that can, have just a few seconds of your voice and clone a voice, to make video avatars of people that can be manipulated. There has been, a general worry about what is this going to mean for courts and tribunals when we see a bunch of fake evidence now get submitted. We haven't really seen this flood that people were worried about. In terms of reported cases of actual deepfaked evidence, I'm aware of one in California, and I haven't seen too much of this happening or being reported to happen in Canada. So certainly definitely not a flood. One thing we are seeing happen, though, are self-litigants unsuccessfully claiming or expressing concern that certain evidence in a matter is deepfaked, and then adjudicators having to react to those claims. So, if we aren't seeing the actual deepfake evidence, we are seeing these deepfake allegations. And, I think there's probably a wide variety of reasons this happens. I think there certainly are people that are seeing this technology out in the world and have legitimate concerns about whether evidence is real or not. They've seen how easy it is to create things, and that information's in the environment. They're also going to be a worry that someone may be strategically, making a bad faith claim that something's deep fake. That could be happening too. And so, these concerns are happening probably from a variety of different perspectives. There's a handful of cases in Canada dealing with this. The most extended commentary on this is from that I found is from a Ontario criminal case from December. And there was an accused who was self-represented there who wanted the court to consider that the Crown video evidence against him was deepfaked. The court took this very seriously, and this is just a couple of excerpts from the treatment of this issue. Ultimately found there wasn't a need for bringing in a forensic expert. The court felt that they could rely on the testimony of the officers that were in the video, but did caution, and I think you'll see in these paragraphs that courts are going to need to seriously consider how to assist someone who may be economically disadvantaged, who disputes the authenticity of digital evidence and maybe can't afford an expert, but how do you ensure a fair trial? But then also the adjudicator needing to maintain independence, and did emphasize, the ruling in this case doesn't mean that the Crown's never required to provide more evidence, that the digital evidence is authentic, and noted that, as this may be coming more and more up in cases, do we need kind of to think about new processes? And there's some work, at least on the civil side in Ontario, thinking about do we need new rules potentially about how we handle these claims, just so we're doing them fairly and also efficiently. The seventh observation has to do with filing volume. And, in terms of why I included this is that just like there was a concern that there might be a flood of deepfake evidence in our courts and tribunals, there's also been a concern in the United States and also in Canada that as we have this powerful tool that can create text so easily, are we going to just see a flood of submissions? Will courts and tribunals be overwhelmed with a bunch of new filings? And I'd be really interested to hear from our panelists about what they're seeing in their courts and tribunals. I've mostly heard of this actually being an issue at federal court in terms of some of the immigration docket, but it may well be, appearing in different areas in Canada. I don't think every court's, experiencing an uptick, but there may be some of that. One thing I've also heard from tribunal adjudicators is that they're seeing maybe not an uptick in volume, but an uptick in length of submissions that they're receiving. And so in some cases, because there's not page limits, receiving kind of hundreds and hundreds of pages and finding ultimately that's not going to be helpful for the self-litigant because self-litigant might not be aware necessarily what's in the filings. It takes a long time to kind of get to the real issues. And so even some consideration, do we need different practices or different limitations to kind of deal with this issue? Because more is not necessarily better, though more is very easy to produce now. In terms of where to go from here, I'm just going to offer some initial thoughts. We really do have the experts on the panel who are going to have the best perspective on this. But I thought I'd offer kind of some initial ways that I'm thinking about this and talk about it kind of from the perspective of different stakeholders. So looking at, courts and tribunals, I think overall in Canada, courts and tribunals are doing their best to educate the public about some of the dangers and limitations of this technology. We have practice directions and sometimes also notices. I think we need to continue to do as much public education, all of us, as possible. Can we have a better way to, make the guidance even more accessible if it's not, included in a filing portal or in physical filing spaces? Is there a way we can kind of bring this issue to the attention to people better, or maybe even earlier in the process? Is there a way we can drive the point home more, kind of give people examples about how this tool can be limited and what can go wrong? When there's a good, cases, also giving people examples of this going right, like we saw in that other reported decision. Certainly I think kind of all legal stakeholders need to start to build and maintain AI literacy if they haven't already, because this is kind of now just in the environment. It's kind of ambient, is what I say. And so whether or not you're, a self-litigant or you're an adjudicator or you're a lawyer, or you're a law professor like me, having some knowledge about the technology is going to be really important. I put leverage decisions in public education. I certainly understand that decisions are about the case at hand and the parties, but as much as we can also, as a matter of public education, make sure that there's as much awareness out there about this issue, I think is all the better. There's some courts and tribunals creating internal reference tools, and we can maybe hear from our panelists on this. I do know of one Ontario tribunal that's created an AI hallucination detection checklist for tribunal submissions. And so trying to think of a way to help the adjudicators in that tribunal think through what they need to be looking out for and also think through like how to best react to this issue. So I think those things can be helpful. And again, we do have the real experts on the panel that are going to tell us their perspective on this. To the extent we have lawyers with us today, some of the same things that building AI literacy and being vigilant, whether or not you are posing a self-litigant or posing another lawyer, know that this issue can be out there. There's some courts now in the United States that are sanctioning opposing counsel for not noticing problematic AI submissions of the person on the other side. And so, more and more being aware and looking out for this can be important. I think particularly when you're dealing with self-litigants, do that verification. But I think, I put don't vilify. I think people are really, doing their best when they're using these tools. The tools can be quite deceptive. And I think, the goal is to, I think, protect the integrity of our processes rather than, put someone up there as an example, as a villain. And so I think our roles as, guardians and safeguarding the administration of justice should be the focus of that exercise. Certainly in my view. For self-litigants, what's my perspective in terms of some guidance? I think certainly when you're using those general purpose tools, caution is in order. ChatGPT is certainly in my view not going to be a great legal research tool for most people. Can give you the right answer, absolutely. But it's going to be really hard to check that there's no problems in that answer unless you're a legal expert already. Again, I don't think it's going to be a great source for expert evidence, and it doesn't seem like, I think probably for good reason, Canadian courts and tribunals are accepting ChatGPT as an expert. Can you use this tool for other things? Can you use this tool to help with your writing, to get your ideas across? Yes, I think you can. I think that could be sometimes the hardest part for self-litigants. Again, this needs to be done carefully. Does what you submit represent your understanding of the facts and not the tools remixing of what happens? And so I think, care is certainly still in order. And, also increasingly there's specialized legal AI tools being developed. We certainly see a huge market for wealthy law firms and governments, but also for the public. Slowly we're seeing some tools being made available, and sometimes those can be really helpful, and oftentimes they're going to be a lot safer. And I'll end, the last few minutes of my remarks here just talking about some of the legal AI tools designed for self-litigants. There's a lot happening in BC. I'm not going to be able to capture everything. And please, later, when we have a conversation, people can bring up other things I don't know about. But in terms of some examples, we can talk about legal information AI chatbots that are available in BC. People may be familiar with People's Law School, who have been providing Beagle Plus, I think, for roughly 2 years now. And so this is a chatbot platform, but it's built by People's Law School to very much connect with its repository of verified information. They've done a lot of effort in training and building controls and rolling this out very carefully. I've been told over the last 2 years it's had over 15,000 conversations and really positive feedback from people. I understand one of the things they're working on now is also adding BC court forms to the database. So the tool can then also provide information about how to fill out those forms to some extent to people. And so providing legal information and a specialized tool that still uses the same technology. You'll see it says ChatGPT 5.2, but has kind of a layer of controls built over it. Justice Education Society also has its Ask Jess AI hosted, where I found it was on the Family Law in BC website. Again, builds off the knowledge base that they verified, trained to only give answers based on that verified information. And so kind of trying to control that guessing feature of that technology that gives rise to so many problems. And so those are examples of legal information chatbots that are going to have a lot more controls and be a lot more kind of bespoke for the BC litigant environment. In the form creation area, we certainly can have kind of tools like the BC Online Divorce Assistant. Many of these tools aren't necessarily using AI. They're using kind of a different form of automation, but can be a lot more user-friendly to the public. I did a study actually about some of these guided pathways versus, it's the PDF court forms, and people find it much easier to engage with a more kind of streamlined system. Not in BC, but one thing that I think is interesting is happening in Canada is CLEO, which is Community Legal Education Ontario. They have a guided pathway system to help people complete court forms, very rules-based, not that generative AI, but they're looking at whether or not they can insert generative AI at certain aspects of the court forms. So one thing that studies find is when self-litigants need to fill out aspects of court forms where you need to provide an explanation or a narrative. People find that hard. They don't know how much detail to provide. They don't know what's legally relevant. And so they're looking at whether or not you can kind of insert generative AI at a very strategic spot, kind of within a much more controlled system to help out people. They've been doing a pilot, I think, again, it was over the last 2 years or so, seeing if this can help. And they have some publications talking about that. The final category I'd address is the legal research space. And so those chatbots are kind of more for legal information, but here talking about case law, legal research. I mentioned some of the limitations in using a tool like ChatGPT for case law and legal research. Of course, we have CanLII in Canada, which is free to the public. It does have some AI offerings. So it started in certain jurisdictions having AI summaries of cases and legislation. I think primary audience is lawyers, but you can see why summarization could be helpful for the public. As far as I know, British Columbia cases are not included in that feature yet, though I'm told they're hopeful that they can include them in the near future. They're also at CanLII looking at developing more AI capacity in that platform and have done a pilot over the last few months as well. So there may be more coming from CanLII, and again, a much more kind of trusted source with verified information. One issue, and this is a big issue, and I'll only get a touch on it really quickly, is some of the challenges for people who want to develop tools for the public that draw on case law has been the issue of access to case law. And so, there's only a few holders in Canada of complete case law. And even public sources like like CanLII do restrict access in terms of what a developer can maybe do with their data set. And you may have seen there was a lawsuit in BC that CanLII brought against a legal tech company. Some recent news that's moving towards settlement. And there's people in Canada, advocating for more access to case law so more development can occur. Certainly a complicated matter that has a lot of considerations, including privacy considerations, including equality considerations. But I think more and more coming into the mainstream knowledge. There was a big coverage of a court record and court data access in the Globe and Mail recently that you can look at. And so I think some people think that all case law in Canada is kind of fully accessible to anybody, and that's just not the case. And so there's been some thinking about how can we move forward in a responsible way to make this law more accessible so it can be used in tools for the public. See, I'm rounding off to my last minute, and I'm on, I think, my second last slide, so that's perfect. In terms of final thoughts for what they're worth, I always like to encourage people to bring a mindset of curiosity and caution to all of this. I think curiosity is a great way to approach a lot of things, including the issue of AI and the justice system. I think it's good because it moves us away from maybe being fearful or overwhelmed. There's a lot that can be overwhelming with AI. I'm someone who tries to keep up with this, and there's new news every day. But I think if we stay curious, we're in a learning mode. I think we open our minds, and I think if we stay curious, we also are take some agency. I think we should also recognize there's a big industry behind all this AI, a lot of hype out there. If we're curious, I think we can start to take even more control about how this technology is being used in our justice system, because I think we're the ones that should be deciding this, not necessarily the industry. But I think caution is still a really healthy thing to bring this whole conversation. There's a lot we don't know. This is moving very fast. Trying to sort out what's hype and reality can be very challenging. Technology is still evolving, so we're not at the end point. And so I think we certainly shouldn't kind of put our heads in the sand, but also taking a breath, slowing down is also okay. You don't need to learn everything all at once. You don't need to be using all the technology all at once. So I think, being curious and being cautious is a great way to think about this. And with that, I'll thank you for your time and attention again for coming today. And I'm really looking forward to learning from our just amazing panel that's going to be following me. Thank you, everyone.
Thank you, Amy. That is just a stellar presentation. This is such a complex and dense area, but you have both parsed out interesting pieces and gone into depth and also left us with some hopeful, helpful ways of approaching these things. It's a pleasure now to turn to our panel and to ask some questions. Now, we have about 30 minutes. What I'm going to do, just for the panelists to be aware, I'm going to proceed in the order of Tim, Judge Wishart, Shelley, Emily, and Aaron. And for each question, we have 5 questions. I'm going to proceed to start with the next person. So We have about 7 minutes per question if we take them evenly. And if there's anything that you don't want to tackle, please feel free to pass. But we'll try and get into some good stuff here. So the first question, for each question, by the way, I should say, I'll invite everybody to weigh in if they'd like to on each of these topics. And so, but Tim, turning to you to start this first one off, many of the points that Amy has made, there are points of concern, points of caution for courts and tribunals, whether those are fake cases or other ways that generative AI has been used in submissions. So the question for everybody, but Tim, first to you, is this something that you've seen in your tribunal or court? How much of this have you been seeing? And what are some of the particular challenges that it's posed?
Sure. Thank you, Andrew. And thank you for the amazing presentation and excellent summary of the landscape out there. So I'll say the answer to your question is yes, that we are seeing people using generative AI tools in their submissions. And how often are we seeing it? With relative frequency. And our court has chosen to treat, at least for now, artificial intelligence tools in the same way as one would treat really any other tool. And there's a long history of tools that have been developed over the years to enhance or assist people in their litigation. And that involves both self-represented litigants and lawyers. And so what I'm seeing is self-represented litigants use generative AI in a lot of more basic procedures before the court to their advantage. So, for example, in the Court of Appeal, we run the full gamut of self-represented litigants that are dealing with immediate issues. Say, for example, an appeal from trial court judicial review in a residential tenancy situation. It may involve somebody looking for answers very quickly. And so generative AI has been very, very good at explaining to a self-represented litigant what the test is for something like a stay or security for costs or the sort of basic applications that we deal with here in the court. And what I have seen is an increase, frankly, in the quality of the submissions that we've been getting for some of those basic applications. People use AI, they understand the basic test, and AI is very, very good at explaining well-known basic legal concepts to self-represented litigants. We have pretty strict page limits here, so I haven't seen kind of the run-on submissions, but it is pretty good at laying out that test. What it has not been very good at has been more sophisticated applications. We are getting into applying evidence to appeals themselves and dealing with more challenging types of analysis, like standards of review, or getting into trying to synthesize evidence into a legal test. And so in terms of the advantages, I mean, I wrote in a case called Wu and Murray that, generative AI tools, they can be useful, and they are useful to self-represented parties to distill and understand complex legal principles. And that's why in our court, we don't require parties to disclose whether they've used AI or not. What we do is we require parties to ensure what they're putting before the court is authentic and correct. And we've added that into our some of our public-facing materials to make sure that parties know that that's the expectation. So I think at the stage that it is now, and this is sort of setting aside the concerns around deepfakes and evidentiary matters, which are a bit different, I treat AI as any other tool would be treated, which is used to enhance or make efficient the litigation process. And if a self-represented party wants to come before this court and use artificial intelligence, if they're aware of the risks, and I think that the comments that were made about education are actually really important here, and setting expectations that, I see it as something that can help demystify and bring the appellate process to a place where it is more easily understood by people that are representing themselves. So I know we're short on time, but I'll leave it there. But in terms of challenges, not as many as one might think, I don't think.
Thank you, Tim. And Judge Wisher, over to you to weigh in for the provincial court.
Just want to make sure you can hear me. Yes, great. And sorry, am I answering the same question?
Yes, please. Just
Yep.
Challenges
Yes.
and how often the provincial court sees this.
I echo everything that Tim just said in terms of our approach. And I have not seen, I'm not sure there have been any hallucinated cases presented in provincial court, but I am aware of a situation where a self-litigant used AI to help them with their submissions. And I expect one of the prompts that they used was put this into legal language. And the judge said it was unintelligible in terms of all of the legalese that showed up. There was Latin. It was just not something that the person clearly didn't know what it meant, and the judge didn't know what it meant. And that was the explanation, like, oh, I asked ChatGPT to put this in legal language. So that's only the one situation that I've heard of it being a problem, but similar to the Court of Appeals approach, this isn't new in terms of lawyers, self-reps, anybody coming before the court has the obligation of making sure that it's accurate and authentic, whether it's submissions or documents or case law. And we're not issuing a practice direction, but we will have something up on our website in the next few weeks with a caution around using AI because it can be inaccurate. And then again, just setting out that obligation. We do not require people to disclose if they've used AI, again, similar to Court of Appeals approach. I don't ask people if they've used the internet. I don't ask people if they've had a friend assist them in filling out their paperwork or submissions. But if a judge asks if somebody has used AI, they would be required to disclose that. So similar approach to the Court of Appeal. And at this point, have not seen a lot of challenges to date.
Thank you very much. Shelley, I'm going to turn to you. Some of the Civil Resolution Tribunal decisions made it into Amy's presentation, but I wonder if you could take the same question.
Sure. So I certainly resonate with what Amy's presentation said. So yes, the short answer is we see a lot of repetitive, lengthy submissions. Many of them include fake cases or correct, semi-correct citations, but that have the wrong ratio set out or incorrect quotes, or the submissions that are just super long and they don't even address the substantive issue that is before the tribunal member. So just for background, we had 8,800 new disputes last fiscal. About 55% of those are small claims. And in anticipation of today, I consulted with my vice chairs who do all the, sort of a peer review process of draft decisions. It always remains the ultimate decision of the assigned tribunal member, but they see everything is the reason why I'm asking them. So they write their own decisions and they read everyone else's. And just to get a flavor or a pulse of how much this is happening right now. And so this is very anecdotal, but about 75% of small claims disputes have AI-generated subs or AI-assisted subs. The made-up cases is more rare in small claims than it is in strata, which is quite problematic there. And I think the sense is that AI is good at summarizing in plain language, especially if someone's not a native English speaker, but it is terrible at coming up with legal arguments afresh, especially in a sort of more niche area that strata might be than a regular small claims dispute about a simple transaction. So we also have problems with certain, I guess, certainly intimate images is an area where it's a real problem sometimes. And part of that may be because very little is published in that area. We publish everything else, but for intimate images, we do not for obvious reasons, and we're not required to under the statute for the protection orders. So there's little for people to go on, I think, sometimes in that sense of how to come up with an argument about it. Your question about the challenges, it takes a really long time to adjudicate them. it's just incredibly lengthy, and it can lead to what amounts to cost consequences, as you saw in some of the decisions that were cited. And I have some of those reference for another question, so I'll leave it at that, I think.
Thank you. And Emily, I'm going to turn to you. Same question again.
Thanks, Andrew. At the Employment and Assistance Appeal Tribunal, we're dealing with appeals of denials of social assistance, disability assistance, and childcare subsidy legislation. And we're definitely seeing an increase in a generative AI with submissions, as well as one instance of the creation of evidence. And with submissions, it's sort of, I agree very much with what Amy said. We see the benefit in when someone has taken their own ideas and their own submissions and put them into generative AI to have them formatted or organized or expressed, perhaps in more depth. That can be quite helpful. But what isn't helpful is when people ask generative AI, and it's quite obvious what they're doing when we see the submissions, broadly, make a case for me about getting disability assistance or something like that. And what we see are submissions that refer to federal disability programs rather than the provincial. The test is very different. We see cases that are either hallucinated, but sometimes they're cases from the wrong tribunal that don't deal with the same legislation, or sometimes they're employment cases that I guess we have employment in our name and we get cases from the Employment Standards Tribunal showing up in submissions, and they're not at all relevant. And so we see that, and it's problematic because it takes time, as Shelley has said, to deal with them through the adjudication process and at the hearing. We also have that one mention I said where we had someone, they admitted during the hearing that they had asked AI to generate submissions and evidence for their case. And AI certainly did that. We had a generated medical note from a AI doctor, I suppose. Questions were asked when it wasn't signed and didn't look like, it wasn't in the medical package. And so all of that is problematic. And so we are we have draft guidelines in the works that encourage, not encourage, but say that certain use can be beneficial, but cautioning on the other use. And the biggest challenge, other than sort of making things more cumbersome, is it sets unrealistic expectations for clients. And most of our appellants who appear in front of us are self-represented, and they're going through this themselves. Maybe 25% might have an advocate. And they're having these unrealistic expectations because AI has told them, they've got this slam dunk case. And then they're not providing the evidence that they might otherwise have provided. In many cases, I think people would be better off without the AI submissions that are hallucinating things and just muddling through on their own, because we're quite skilled at being able to ask questions and tease out information and get to the nub of the issue. And when we're clouded with the AI submission, it makes it harder to do that.
Thank you, Emily. And Erin, over to you.
Thanks. Yeah, just for some context, the Property Assessment Appeal Board is the second level of appeal for most property assessments in British Columbia. And so because of that, we have this annual appeal cycle. So what that's allowed us to do is kind of think of this in these like yearly chunks as they come through, which so last year we had about last calendar year, we had about three decisions involving hallucinated cases. That is not going to be a full representation of everyone who may have used AI to assist them in creating their submissions to the board. all of those ones that are great uses where they're helping people write more concise and clear submissions, we wouldn't have necessarily been aware of those even although we will talk about in the next question, the board is one of the tribunals that does require active disclosure of the use of AI in generation of submissions. The main challenge that we've seen when we've had these hallucinated cases come up has been just the time and resources it takes. Like all of my tribunal friends were required to create a procedurally fair process to address any allegation of a fake case that may come up before us. So we have to create process around that, decisions around that, determine appropriate sanctions, if any, while being sensitive to the fact that the majority of folks who come to the board are not represented by counsel, although many are represented by agents, and are dealing with having to learn two different distinct and niche areas, both appraisal and the law within our context. So that's what we've seen so far.
Thank you all. And now I'm going to use moderator's prerogative a little bit here in view of the time. And I'm going to try and push together our next three questions. So I'd invite you, if you have answers to any questions broadly under responses that your court or tribunal is taking to this, and particularly any responses that may be relevant or helpful for self-litigants. But this could also include whether the tribunals themselves are using AI in ways or trends that you'd like to see. So apologies to push everything together here. And Judge Wishart, I'm going to start with you, but broadly then, under this theme of responses, you mentioned that something will be coming up, a caution on to the court's website in the near future. Are there any other responses that your court is engaged in or that you hope to see in the near future?
Yeah, I think we're in early days. I think there was the same concern, with the launch of the internet. What does this mean? Same with AI. What does this mean? We don't know what this means, and I really appreciated the presentation by Professor Salazin, because there's a lot of unknowns, and so the court is taking a very cautious approach in terms of how the court itself uses AI, which at the moment is really not at all. And we do have an AI committee, and one of the things that we are exploring is legal research, because judges do engage in that, and there are a couple of well-known providers of legal research that have an AI component, and making sure that it's a closed system, so it's only accessing the cases and other materials within its database to do research, so you're not getting any risk of hallucinations. But again, there's still cautions with any use of AI, and so we have not taken an approach of any sort of specific use of it at this point in time. We're very interested to see how it can help self-reps. And as part of my work, I attended a webinar that was in the States, and the People's Law School from BC was one of the presenters about Beagle. And I thought that was a fantastic product. Again, it's a closed system, so it's only using information that they've developed and verified. And I think that those uses have a lot of promise. But at this point, the court is just taking a very cautious approach to AI. And I'll end there and let others contribute. Thank
you. Shelley, can I turn to you with that?
Sure.
Somewhat mangled question. I apologize.
No problem. So we do not have an outright ban on AI here, and nor do we require disclosure that people have used it. We can usually tell from the subs. So we leave the consequences of misuse of AI to the tribunal members' discretion about what to do about it and what to comment on, and that includes potential cost consequences. We do have a new rule that's effective at February 1 on false evidence or fabricated evidence. It really just codifies what they were already doing anyway in terms of more general rules, but it's meant to be a tool for our staff to give to parties upfront and say, here's a rule, you cannot use fake cases, and there's a potential costs or expenses, order for time spent if you do. And part of this rationale was that we recognize self-represented litigants are usually doing their best, and they may not intentionally mislead by relying on AI. So we're trying to strike a balance with the cost part of it. So only if a tribunal member typically concludes that the party ought to have known or was reckless in using the AI-generated material. And we already talked about the cases that we have. We've probably had at least 20 or 30 published, or including some of the IPA ones that are not published. You can find them if you use the words like hallucinate or false evidence, that sort of thing. What we're doing internally, so when we started, we have a solution explorer, which is sort of really basically rudimentary AI. It's guided pathways. And that's where almost everyone who wants to file a claim with the CRT goes onto our website. It's free, available 24/7, and they go through that. And it's a question and answer format. But that's not generative AI. And so we did have a demo when we were looking to be upgrading our platform, which is currently on hold, but a demonstration of like a chatbot that would overlay that solution explorer. And the demo, they said, was controlled inputs, so it was not good enough. It was not ready for prime time. It came up with wrong answers. And at first, there was some pushback. They said, well, but it must be that your source information is wrong. So we said, well, show me the source. And they were able to go behind the scenes and produce it, and it just was wrong. And I was not prepared to have something public facing. One of my vice chairs issued a decision a year or two ago, Moffat and Air Canada, about how to the effect that Air Canada was held responsible for the information it had given through its chatbot to a passenger. And in my view, the same would apply to us. So we're not moving forward with that. But internally, it is good at things like concision, plain language. So staff can very cautiously use the Copilot that's made available. Here, it's much lower level than ChatGPT 5.2, that's for sure, to produce, help them draft emails. But you need a human eye all the time because it's often wrong. Yeah, thank you.
Thank you. Emily, to you about responses to AI.
Yeah, the tribunal will be issuing a practice direction or guideline about providing caution about some of the problems that we've spotted with the use of AI. The other thing that we're making clear is that AI is never used with by our adjudicators making their decisions, that the decision granting or making authority is granted to the members who are assigned to hear a hearing, and that it can't be delegated to Grok or ChatGPT. And also, the guidelines that we're putting out also warn our appellants and parties appearing in front of us, particularly appellants, because the others are the ministry, so they're more aware of these risks already. A lot of the evidence people are using in their cases are health records and financial records. And we're warning about the risk of putting that information into ChatGPT or any AI platform, and the confidentiality risk that you're saying goodbye to privacy for that forever, really. And so we're cautioning and providing education that way. The other thing that we're doing, because of the population that we serve, and the majority of our clients who appear in front of us are self-represented, many from vulnerable populations, facing extraordinarily more barriers than other populations in access to justice. We're trying extra hard. We've always tried hard, but we're trying extra hard to make information more readily available, more accessible, easier to read, and to really get the message out there that we're there to help you, and that there are advocates out there who can help you if you're stuck. And so not just leaving people wanting to use ChatGPT for help, but trying to create a process where people don't feel the need to have to go use AI to get things done, where they feel that they can tackle it all on their own, and to know that, coming in with some point form submissions, that's okay in our world. It might not work for everywhere, but it works for us, and that's fine.
Thank you, Emily. Aaron, over to you for the Property Assessment Appeal Board response.
Thanks. And so we caution our folks at about three different places right now, and we're looking at maybe adding a fourth about use of AI at the board. And so it's on an information sheet regarding evidence. We have our code of conduct in the rules, and it's contained within the board order setting appeals down for hearing. In terms of our own use of AI, similar to many of these other bodies, we're looking at simplifying some of the information available on our website, potentially using AI to help bring those documents, either collect them, make them more easy to access through natural language searches. But we want to apply that same disclosure and transparency that we're requiring of folks to ourselves, and want to make sure that where we are using these tools, we're making sure that they're all accurate. We're making sure that we are potentially providing what the old information was, so that if folks want to rely on the pre-AI version, they have access to it. And just looking at what appropriate accountability to the public that we serve looks like when we are using these tools. Same as with Emily and inevitably all of the other groups as well. Decision making is a human job, and there are only humans making the decision. Potentially in the future, perhaps formatting of decisions could be done using something more robust than just the word review tools. But that's not where we are right now. And hopefully we could get there. We have some concerns regarding data security and the container that the information is kept in, just given that our backend is all managed by government too. So making sure that us as an independent tribunal have our data properly basketed is a concern for us.
Thank you, Erin. And finally, on this question, Tim, over to you for the Court of Appeal on responses.
Sure. So as I mentioned earlier, our approach has been to caution people about the use of AI. We haven't taken further steps other than basically to release that cautionary aspect, but we do have a number of tools that we've developed in partnership, particular with Justice Education Society, a set of guidebooks that provide a lot of the information that actually turns up in ChatGPT and other generative AI solutions. So it would be, it's interesting to see that even though we have, provided some resources for people to get basic information about the conduct of appeal, the impetus seems to be to seek, the relatively straightforward and easy use of AI to get that basic information. Like I said, that's important. Now, in terms of the work that the court is doing on artificial intelligence, we're obviously bound by some of the codes of conduct that have come out, including the Canadian Judicial Council's guidelines that were published in September 2024. There's another number of other organizations, international and local, that have published guidance documents about what courts should and shouldn't do. Our philosophy is to remain open-minded about the internal use of AI. And I think that a number of my fellow panelists have alluded to the concept of a captive AI. And I think in circumstances where a court can rely on artificial intelligence that isn't sharing that information or necessarily learning more from that information, and we have some arrangements with some AI providers to explore that possibility. Then the ability of a court to potentially use AI in some of its basic functions, nothing relating to decision making, of course, but some of the lead up to the decision becomes a possibility. I think my concern with AI, and this has been echoed by panelists, is confidentiality of the information. It circles back to some of what Amy was talking about with respect to even court decisions. This court and other courts in BC take the position that we have a supervisory responsibility for information that's provided by litigants to our court. We take that very seriously, and we are very cautious about the implications of feeding information to an AI, particularly if that AI is going to be out there permanently. As Emily suggested, that information, once it's out of the barn door, it's out forever. So there are opportunities. There are certainly opportunities. They range from the way that we manage cases, case management system, to the way that we prepare to hear cases, and some of the more basic things that we do, including summarizing cases on our website. These are uses of AI that potentially could be something the court could look at, but there are a number of conditions that would have to be satisfied before we got into that. And most of those conditions, in my mind, have to do with the privacy and confidentiality of information, and receiving certain guarantees that that information will be not transmitted beyond a certain place to ensure that those records are responsibly managed. So thanks very much. Those are my comments.
Thank you, Tim. Now, we are getting close to the end of this part of the session, very close. In order to preserve enough time for questions from other folks in this webinar, I want to ask each of you, if you can, to keep this last answer to maybe 30 seconds at tops. And really, this is a final thoughts. Anything else? Is there anything that you'd like to add, or any final thoughts that you'd like to leave the other panelists and folks attending today with? And Shelley, I'm going to turn to you first for this one.
Sure. Two things. We do have an internal AI subcommittee, and mostly that's led by one of my vice chairs who is really into this sort of thing and keeps track of it. And one of the issues is making sure that when we start to see more AI generated evidence, like documentary evidence, like medical records or doctor's notes or whatever, that we're actually able to detect it. Because right now I don't know that we necessarily could unless it was so obviously poorly done. The other thing is that we're considering using guided submissions in other areas beyond the intimate images stream. And I think that will help with the lengthy, repetitive fake cases part where someone's just going into it thinking, I don't know how to give subs, so I guess I should go to ChatGPT. For intimate images, we have a series of questions, the answers to which are what we expect a tribunal member wants to know in order to make a decision about whether, for instance, it's an intimate image, was it shared without consent, should a protection order flow? And so we're looking at doing that format in other areas, not necessarily all small claims, but maybe we would start with something like used car disputes or things like that to see if we can sort of, it would help with shortening the submissions, but it will also perhaps address the AI problem.
Wonderful. Yeah. Thanks, Shelley. Emily, to you.
I think unsurprisingly for anyone who knows me, my final comment is to keep in mind while we talk about AI, the percentage of the population who doesn't have access to technology, who doesn't have access to AI. We're talking about AI as it is today, but I think we can all foresee a world where AI improves and it's more integrated into everything that we do. And I always pause and urge others to do the same, to say, that's great, but how do we make sure that the percentage of population that doesn't have access to AI or computers or email or smartphones, how are we going to make sure that they still get good access to service and aren't missing out? We can't ever get to a place where we're just relying on tech to provide the access that I think all of us and our various organizations need to be provided.
Thank you, Emily. Erin.
Yeah, just encouraging folks who may be self-represented at one of the tribunals or courts just to always remember the Wikipedia caution of citation needed and going to that first level source, whether that's a case or the actual evidence, just to see if there's any piece that's slightly off for you. And I am anticipating that in my group, we will probably be looking at getting some unknowing submissions of AI staged real estate photos that will be coming forward in the next little bit. So always looking back at those original sources and seeing, like, were there any notes about those pieces just before you are providing them, because we do expect folks to stand behind the work that they are and submissions that they are providing to us. We need to be able to rely on it. That's it.
Thank you, Erin. Tim.
I don't have much to add. I think my colleagues on the panel have summarized my thoughts pretty well. I think I would just say this, that just double check your submissions. That's all. Really, if you're using ChatGPT and it's citing cases, click through to those cases and take a look at them and make sure that they stand as best you can for the principles that you're putting them forward for. And really, I think that's the main caution. Just make sure that you know that you're a person who is finally responsible for what comes before the court, no matter what it is, whether it's a submission, whether it's a case, whether it's a piece of evidence. As has always been the case with any litigation tool, you use it cautiously, but the buck stops with the person putting the material before.
Thank you. And finally, before we open it up for Q&A, Judge Wishart, to you.
Well, my thought running through this entire session is, even though I did not meet with the other panelists in advance, I'm very happy to hear that we're all taking the same general approach. So that's encouraging. One of the things that I do worry about is with the ease of getting an answer from ChatGPT, that people won't be going to the many wonderful services that we have in British Columbia for people to get help with court proceedings. And so I'm hoping that we're not going to see a decrease in people accessing those services, and also wanting to make sure that people who are providing those services just aren't relying on AI to help people out. And that, again, as Tim just said, that you have to check your work to make sure this is actually accurate and authentic.
Well, thank you all for such a quick but diverse sprint over 5 different courts and tribunals. I'm going to turn it over to Jenny now for our Q&A period.
Thanks, everyone. So Rachel is going to stop the recording of our session before we jump into Q&A. And we did notice that the chat function may have been disabled. There may have been a glitch there. So we'll turn it on for this portion. And if anyone has a question,